purpose. The effort to train young lawyers, to strengthen professional competence, and to cultivate leadership within the bar is therefore central to our mission. One of the most meaningful initiatives of Adhivakta Parishad is the tradition of study circles. Across the country, advocates regularly come together to study statutes, discuss case laws, and reflect on contemporary legal and social issues. Taking it forward, we have launched an online study circle on behalf of the Supreme Court unit in the memory of Justice S. Parvatha Rao. This is the fifth edition of that lecture series. Another distinctive initiative is the Nyaya Kendra Free Legal Aid, where Adhivakta Parishad has consistently organized workshops, seminars, webinars, and training sessions to enhance knowledge and skills of advocates and judicial service aspirants, creating a valuable platform for dialogue, making the legal system more accessible, humane, efficient, and responsive to the needs of the society. Its quarterly journal Nyaya Prava further carries this intellectual and social engagement to a wider audience by bringing together judges, advocates, researchers, and students on issues of social legal importance. The mission before us is large but clear to ensure that justice is available, accessible, affordable, and acceptable to every citizen, including the last person standing at the farthest end of the society. Adhivakta Parishad has been striving to discharge that duty with sincerity, discipline, and commitment. So, today, I invite all advocates, students, and members of the legal fraternity present to see the practice of law as not merely a profession, but also as an instrument of justice, social harmony, and national regeneration. Let us come together, connect, and contribute to this larger cause. Thank you so much. Jai Hind.
Thank you, Megha ji. We now come to theme of today's lecture, and I think the theme before us this evening is deeply reflective. Freedom won, freedom defended, 80 years of independence. To give a little introduction to this theme, I think 80 years ago, India woke to freedom after a long and extraordinary struggle. Our independence was never conceived as transfer of one political power from one set of hands to another. Freedom movement carried within it a much larger aspiration, which is creation of a nation in which Bharatiyas would govern themselves, shape their constitutions, determine their own destiny, and live under a constitutional order founded upon liberty, equality, justice, and dignity. That is what makes today's theme, Freedom Won, Freedom Defended, particularly significant, because Freedom Won asks us to remember. It asks us to remember the sacrifices of countless great men and women under whose courage, conviction, and perseverance made independence possible. It asks us to remember that the freedom we exercise today was not inevitably nor freely given. It was earned through enormous personal and collective sacrifice. But freedom defended asks us a different and perhaps more difficult question. What must each generation do with the freedom it inherits? It is a continuing responsibility. For a constitutional democracy such as ours, freedom is defended not only at our borders, it is defended every day through the strength of our institutions, fidelity to constitutional values, responsible exercise of rights, performance of duties, and willingness of citizens to participate seriously in life of the Republic. And for members of legal profession, this question, I think, has a special significance. As Bharat reflects upon 88 decades of independence, we therefore have an opportunity not merely to look backwards with pride, but also to look forward with responsibility. What have 80 years taught us about freedom? What has actually strengthened Indian democracy? What has tested it? And what we must preserve, reform, and defend so that freedom remains meaningful for generations yet to come. It is in that spirit we look forward to this evening's lecture. To formally introduce our speaker for the evening, Shri Aman Lekhi, Senior Advocate, Supreme Court of India, I now invite Pramod Bishnoi ji. Pramod Bishnoi ji, over to you.
Good evening, namaskar everyone. A very warm welcome to everyone present here on this special occasion of fifth session of Justice S. Parvatha Rao lecture series organized by Akhil Bharatiya Adhivakta Parishad, Supreme Court Unit. It is a matter of immense pride and privilege for all of us to assemble on the occasion of Independence Day. In this spirit, we are honored to have with us a distinguished member of Indian legal fraternity whose professional journey reflects excellence, intellectual independence, and a deep commitment to the Constitution and administration of justice. It is my privilege to introduce our guest speaker, Sri Aman Lekhi, Senior Advocate, Supreme Court of India, and former Additional Solicitor General of India. Sri Aman Lekhi sir graduated with honors in political science from Hindu College, University of Delhi. Thereafter, pursued law at the Campus Law Center, University of Delhi. He was designated as senior advocate in 2005 and served as Additional Solicitor General of India from 2018 to 2022, representing the Union of India in several matters of far-reaching legal and constitutional significance. His practice encompasses all branches of law. He is widely recognized for his ability to argue with equal command across constitutional, criminal, commercial, and regulatory matters without confining himself to any single field. His name is associated with his several landmark cases, including the 2G spectrum, coal allocation matters, as well as the challenges that led the Union Public Service Commission to restructure the civil service preliminary examination. More recently, Sir led arguments challenging the enhancement of reservation in public services to 73%, a matter involving the constitutional limits governing reservation. At the bar, uh, Sir is admired for the exceptional speed, clarity, and synthesis of his advocacy, particularly his remarkable ability to identify almost instantly the precise issue upon which a case ultimately turns. Please join me in extending a warm and heartfelt welcome to Sri Aman Lekhi, Senior Advocate, Supreme Court of India. Sir, we are truly honored and privileged to have you with us today.
Thank you.
Please, sir.
Thank you.
Thank you, Pramodji. It's now my privilege to invite our distinguished speaker, Shri Aman Lekhi, Senior Advocate, to deliver the lecture. We very much look forward for your reflections, so please.
Well, at the outset, I'm very thankful for the invitation. The topic which you have chosen is doctrinally very rich, and I must compliment you for choosing a very bold topic for discussion on something as significant as our Independence Day. We will for a moment ignore that this is the 80th Independence Day, but the 79th year. The enthusiasm for independence can condone even any minor lapses insofar as the topic is concerned. But what is most important is that what this topic suggests is the nature of Indian constitutional history as a continuing contest over the meaning of freedom. And this is the beauty of India. This is where India stands out as a very unique country. And you have very intelligently distinguished between freedom won and freedom defended, because they are two absolutely distinct chapters. Freedom is won once. In this particular case, at midnight, with its own anthem and a roll of heroes, but it is defended continuously. And why is it defended continuously? Because while we have won freedom from an empire, defending freedom will entail us resisting the misuse of power by our own. And why I say that is that the decades which we have passed in our constitutional history have shown that almost never has the threat to a constitution come from outside. As far as the threats are concerned, the threats come from within and always wear the constitution's clothes. And so it is very necessary to know what is it that a constitution contemplates, because it is only through that we will be able to resist. And this resistance is the obligation of in every generation. These days, Gen Z is a part of everyday dialogue, but where freedom is concerned, Gen Z and all generations and generations to follow too should remember that freedom is inherited conditionally together with the obligation to defend all the institutions and habits through which freedom will survive. And this is absolutely key. Having set the context for whatever I'm saying. Let's begin with the freedom movement because we're dealing with the first part, freedom one. Now, as far as the freedom movement was concerned, you can't just dismiss it merely as representing as demand for replacement of the British personnel by Indian personnel. It has something far more significant, and the significance of that freedom movement was in the vocabulary of freedom. And that vocabulary of freedom, which covered aspects diverse from representative government, civil liberties, speech, conscience, etc., came the basic concept of how the constitution was visualized and what the constitution should actually contain, and which is apparent in the framework of our constitution, because the framework of the constitution, this broadly, because I'm going to deal with it, dealing with different subjects with which it has relate, acknowledges that through 13 that legislation can be vulnerable. It's not as if we have a parliament or we have state legislatures. What they say is in some way sanctified by reason of it being passed. The Constitution recognizes the limitation. The Constitution also recognizes, insofar as the right to approach the court is concerned, the 32 to 26, to actually summon the state. Now that's where the difference between the empire and the government is concerned, because the nature of the governed changes. The nature of the governed changes how? Because we are no longer subjects. We are constitutionally empowered, and because we're constitutionally empowered, we got the right to demand accountability. That is the second aspect. Third, in the trilogy of 14, 19, and 21 is limitation of discretion. Now, that limitation of discretion is another facet of freedom which is earned and freedom which is to be defended together with related aspects. The division of power territorially, which is the federal principle, the accountability, that is, as far as the parliament's responsibility to the executive is concerned, the limitation on the executive itself, and encapsulated in the oath which contemplates not loyalty to the government, but fidelity to the constitution. And that is absolutely the key. And because that is the key, that animates how we have to see how the processes of law work. Because the understanding is that you are not going to look at it negatively, merely as a state which has to be controlled. You have to look at it positively as one which is going to break architectures of discrimination and disadvantage too. To have, apart from a coercive aspect which needs to be controlled, an ameliorative aspect which has to be regulated. And both work under the Constitution. And while we are doing this, let's understand what freedom is. Because freedom is not something which can be loosely used. And freedom, as far as we are concerned, is used in many different facets. Freedom would be used in the Republican sense as we being the sovereign, that is free of an external sovereign, that is in the Republican sense. You will freedom will be used in a personal sense which all of us are very familiar, of the body, of the conscience, of the expression, of the association, of the privacy. These are all different aspects in which freedom, and all these things will become very pertinent when I elaborate upon it. Freedom will be used in the electoral sense, that is in the right to participate in this through a process which is fair, which is regulated by institutions which are credible. That is freedom again, which is there. Freedom would have an institutional facet to it. The institutional facet should bring in the courts, the tribunals, the legislatures, the fourth branch of the government, all those things. That is institutional aspect, fidelity to the constitutional purpose behind which they actually work. That is the freedom in the institutional sense, is how it has to be understood. And freedom would also be used in the informational sense now. Informational sense, why? Because of the structure of technology, the use of data, because the state will now increasingly govern through data, and those will affect all generations, that is reining in what the state can do and protecting as far as the freedom is concerned, where the use of the data is concerned. So when we deal with this as a totality, what we see is that the Constitution is simultaneously, if you look at this context, the Constitution is simultaneously one which is a restraint on power. This is the first aspect. It is a guarantee of individual rights. It is a framework of social reform. It is a structure of territorial pluralism. And it is the manner, the method by which disagreement can be resolved without destroying the republic. And that is where that is freedom, because there has to be this, there'll be disagreement, there'll be dissonance, there'll be differences. But yes, we have a framework. And that framework which works very well, the framework which is apparent to us, the framework which is bringing us today to discuss something, a topic of this significance. That framework to resolve the differences and disagreements without destroying the republic. Now, with this background, let's start with how the evolution of the second part, the defense of the freedom. And the defense of the freedom started very early. The defense of the freedom started very early as the judgment which was in Ramesh Thapar and Brij Bhushan's case, it led to the First Amendment. Now, why is this important? In those particular cases, where the Supreme Court, we had a young Supreme Court, almost the first year of its existence after the Constitution, adopted an absolutely strong conception of free exception, free expression, and invalidated restrictions which did not fit in the original Article 19.2. Now, what did the Parliament do? And what was the Parliament at that point of time? The Parliament was the Constituent Assembly which had framed Article 19, that Parliament, but not yet amended. Now, that Parliament amended that particular article to expand the limitations which came. Now, when that Parliament, which gave us that liberty, expanded it to overcome a judgment, which actually conceded that liberty, what does that show? That shows, one, electoral legitimacy does not necessarily mean constitutional legality. That is merely because it's an elected government. Doesn't mean that whatever it did is legitimate. Number two, overwhelming mandate can also bring in unconstitutionality, which is apparent. And number three, you cannot take freedom for granted ever. That is, you cannot ever concede that the person, the entity, because the tallest person then, Nehru, was responsible for what happened then, and you could not possibly concede to a proposition merely because it emanated from a person of his stature. So that is the reason why the contest from what the freedom was given to how the freedom came to be defended. Now, this led to the change, yes, but did not end in it. What happened subsequently? What happened subsequently was Shakal. What happened was Bennett. What happened? Indian Express. So in each of these cases, there was evolution, there was growth, there was limitation. And what is very pertinent to note is that those cases did not deal with constitutional amendments. They changed the ecology of this particular principle and brought it in the realm of ordinary law. And while bringing it in the realm of ordinary law, notwithstanding the expansive restrictions which were there, defended speech. That is the beauty of India. That is the beauty of our constitution. That is the beauty of our system. That's the reason why we need to celebrate it with pride and be aware of its history and how it has worked. Now, while this is happening with regard to freedom of expression, simultaneously, there's a contesting issue. And that contest came in the sense of A.K. Gopal. Now, while the Supreme Court in Brij Bhushan and Ramesh Thapar was indulgent, it was deferential in Gopalan because it took a very narrow and rigid view of liberty. A narrow and rigid view of liberty, perhaps because of B.N. Rao's conversation at Frankfurter, which was in some way distrustful of the concept of due process, the concept which came much later. Now, because of that, insofar as the interpretation was concerned, it was formal and dry. And that formal and dry interpretation, which created isolated silos for those rights, persisted for a substantial period of time. But though it persisted, it was corrected. And it was corrected gradually and in stages. And that again is the beauty. The beauty, the defense of freedom. And how did the defense of freedom, which came as R.C. Cooper came first, Menka Gandhi came second, Puttaswamy came third. See the arc. We start from a particular movement which more or less deprived 21 of any substantive utility, limiting it to compliance with procedure, to end at a stage when it is filled with ideas doctrinally rich and a test to control the exercise of power of proportionality. So you filled it, Article 21, with various rights. And not only did you fill it of rights, so dried up, in so far as Gopalan is concerned, you also prescribed a method for the purposes of dealing with restrictions on those rights. And I'll deal with proportionality later. But the point here is that this is the defense and a movement forward, and the defense which is owing its creation to the Indian genius. So we have to be as because we normally make fun of ourselves because we don't know our history, we don't know our own capacity, we don't know our own achievements, and that's the reason why memory not only is nostalgia, memory as a reminder of what we are, and memory as a reminder of what we have done becomes very, very important. Now, from these two, let's move towards the social transformation. This was why would I talk about it? Because I'll bring in property, and this is a very, very significant and consequential aspect of our history. And why is it significant? Because this was an institutional confrontation between the courts and the legislature, which engaged our polity for more than 2 decades. And now, as far as this contest was concerned, it seemed to be about property and valuation. But that is a very simplistic way of looking at it, because it has a significance which was much more. It was a battlefield instead of the relationship of individual rights with redistribution, legislative power, judicial review, and constitutional amendment. Now see how rich this is. How we relate ideas to disputes and then reconcile them into a judicial mandate which becomes a precedent and then helps us guide how the polity is to work. Again, the beauty of the Indian mind, which is again at play. Now, what was this? It started with the setting aside of the Bihar land reform, ended with Keshav Bharat. And in the middle were various stages commencing with the First Amendment. The First Amendment brought in 31A, 31B in the ninth schedule. The ninth schedule, which became a dump for all laws, not necessarily connected with the agricultural estates. We'll deal with that later when we deal with Coelho. It took many years till 1997 to deal with the ninth schedule. But the point is, we dealt with the ninth schedule. Who inserted the ninth schedule? The ninth schedule was brought in by the very body which had given us the constitution. Who dealt with that ninth schedule? Who reined in the ninth schedule? Who brought in the principle as to how the ninth schedule is to work? Who protected our rights in so far as the ninth schedule is concerned, notwithstanding the expansive terms? We, through a contest, through adjudication. May have taken time, but it was brought about. And that is it. It was freedom defended. Because we earned, but we did not rest with the earning. We worked on it. And we worked on it to develop it. So this is the First Amendment. This is first. Then came Bela Banerjee. Bela Banerjee was resulted in the Fourth Amendment. The Fourth Amendment was followed by the 17th Amendment. The 17th Amendment brought in Golaknath. Golaknath overruled the law in Sajjan and Samsher Singh. When it overruled the law in Samsher Singh, then after Golaknath came the Bennett at the Privy Purses judgment, which again struck down the bank nationalization and so far as the Privy Purses is concerned. But it was followed by that victory of Mrs. Gandhi, a massive victory, which led to the 24th, 25th Amendment, and eventually it led to the Keshav Bharti case. Now, what did the 24th and 25th Amendment do? 24th and 25th Amendment wanted to undo all that has happened, to give an expansive power to the government, to deal with the issue of amendment, and also restrict the power of the court to interfere with the questions of property and the amount which has to be paid as compensation. So contest, confrontation. Now, what did the contest and confrontation do? Again, what I began with. What I began with was it provided through the adjudicatory process, applying the principles which we derived from the Constitution itself, with a method to address that disagreement and have a resolution within the meaning and purpose of the Republic. And that was the Keshav Bharti case. The Keshav Bharti case, briefly, all of us know what the Keshav Bharti case is. And broadly, in its most simplest form, what Keshav Bharti said is that the parliament can amend every part of the constitution, but it cannot destroy the constitutional order which the constitution creates. So this is the anti-self-destruction principle. That you have got a derivative power. It cannot possibly be used to undo that through which you get the power. And you cannot, therefore, abrogate the system. And what is the system which I began? The system is not those provisions. The systems are not individual articles. The systems are the principles. The principles, the bedrock of the Constitution. So that remained immutable. Yes, there's some criticism. They say unenumerated principle by unelected people to, in some way, affect and immunize any change whatsoever. But the point is that criticism was found to be hollow, because then the basic structure doctrine was used not once but many times over afterwards. And the most immediate was the 39th Amendment, the attempt by Mrs. Gandhi to in some way insulate the Prime Minister's office from judicial review, which was then used by the Supreme Court, which was struck down by the Supreme Court applying the basic structure doctrine. So that is within a short while of this, the worth of the principle, which was then elaborated subsequently, both in Minerva Mills, which restricted the amending power, Vaman Rao, which provided a date that yes, this is how you are going to be dealing with the basic structure doctrine. This is which we have to do. But what is the worth? The question is, we have to understand. Okay, these are judgments. This is the interaction between two bodies. These are the principles, but where does the worth lie? The worth lies in, and I'll put it very simply, the parliament was pursuing a genuine social revolution. But what it was doing while pursuing the revolution, it was trying to insulate its own legislation from constitutional scrutiny. This is what the parliament was doing. Now, what were the courts doing? The courts were defending legality, but the courts were impervious to distributive purpose. That is where the clash was there. Now, why was the clash? Neither side could have had a monopoly over the constitutional virtue. No one could say, okay, what I say is right. What I believe should be the law. So why? Because there's no monopoly on constitutional virtue which is there. Now, this cannot be seen as a victory of one institution or the other, or a property over rights. It cannot be. But what it has to be seen, and this is the beauty of the whole exercise, is it gave three very significant doctrines. And those very significant doctrines are which help us have a disciplined system of governance, limited depending power, judicial review of constitutional identity, and a balance between rights and social transformation. This is the lasting contribution. And these are the doctrines through which we will defend the freedom which this topic which we are discussing talks about. Now, while we are in this, let's bring in a bit of history. Why bring in a bit of history? Notwithstanding Keshav and Bharti, there was a chaotic state between 1973 and 77, as you all know. What was that chaotic state? Immediately, the aftermath of Keshav and Bharti was the supersession. But that it did not end with the supersession only. It was followed by the 39th Amendment, then it was followed by the emergency, then censorship, then preventive detention, then the 42nd Amendment. The 42nd Amendment virtually redid the entire constitution. And most significantly, what came? What came was ADM Jabal. Now, two things come over here, dealing with the first part. When we talk about the 39th Amendment, we talk about the proclamation of emergency, and we talk about preventive detention. What it demonstrates is that constitutional forms can be used against constitutional freedom. And this is very significant because they were formally issued proclamation, formally enacted acts, formally issued detention orders, supported by law, deriving their authority from legal provisions, but having the effect of denying freedom. So forms defeating freedom. That is the first part. Second, what ADM Jabalpur did was the unthinkable. It was the lowest the Supreme Court has ever fallen at that point of time, to the lowest the Supreme Court, because it said there's no right to life, mainly because the right to complain has been suspended. This is out. Now, what does that show? The only person who stood up was Justice Khanna, immortalized by that his particular defense. The man the only man the Supreme Court actually showed was animated by the principles which imbue our constitutional design and remained loyal to them, notwithstanding the adverse circumstances around him, and after being aware of what consequences would follow his dissent. But what does it show? What does it show is that the Constitution can never defend itself. You need someone to defend the Constitution. That someone at that particular point of time was Justice Khanna. And that means that the text, tenure, and jurisdiction. We talk about judicial independence. We say, okay, we use this very loosely. Each of the judges there was protected in their post through a structure which guarantees independence, but failed. The Constitution was clear as to what it meant. That is the text. The text and the tenure were both clear. The jurisdiction, the obligation to pass the order was vested, but yet became the order, negating it. Why? Because what is most important is that the holders of the office should inhabit their constitutional roles. You can't just hold an office. You have to inhabit it. And you have to inhabit it in the constitutional sense. And that is where everyone but Justice Khanna failed. This is the second aspect. But then question is, the lowest ebb. Did India collapse? No. Come 1977, the government changes. But before that, before I deal with the government changes, we talk of the Supreme Court. What we have to necessarily see is there were other constitutional actors, and please keep that in mind. Lawyers are constitutional actors, apart from the others. We are constitutional. That's the reason why I complimented you on the choice of this topic. But the point is, you have to be alive, not just to what the banner says, but what is the meaning behind it and the purpose of that particular phrase which is being used. This is very important, the understanding of it. Plus, of course, the courage, not just understanding, courage and the energy to see it through. We may know it, but may choose not to do anything about it or just let it be, because we don't want to trouble ourselves in the pursuit of it, which is never going to be easy. So the two together. But anyway, coming back to this, what is important is the lawyers filed the habeas corpus petitions. The high courts, the Supreme Court may not have done anything. The high courts resisted. The political opposition was active, though it was in detention. As far as the civil society is concerned, that has preserved the memory of this particular time. That memory has been preserved. And most significantly, safeguards were subsequently incorporated. That is through the 44th Amendment. So what happened was, it was not only that the electorate spoke, the law was corrected. And the law was corrected to make 21 inviolable, to restrict the misuse of the emergency provisions, and basically address the problems which led to that particular situation. Again, what is it? It is freedom defended. Who defended it? We defended it. How did we defend it? We defended it through constitutional means. What did we defend? We defended the Constitution. What in the Constitution did we defend? The constitutional principles which the Constitution contemplates. This is what was the defense of this particular our response. But it did not end with that. There were a series of judgments which followed, which brought about doctrinal reconstruction. So we brought in Menka Gandhi. Menka Gandhi, I've already talked about earlier. That this was a trilogy of 14, 19, 21. As far as the Kapila Hengorani led to the release of the prisoners. Sunil Batra led to the epistolary jurisdiction. Olga Tellis brought in the right to life insofar as the pavement dwellers are concerned. Now there was a growth. Locus standi. Here the Supreme Court says, even if my life is going to be taken away, I don't have a remedy. I don't have a right. I can't complain. Locus standi was enlarged. Now, locus standi was enlarged still further in later period of time, which is beyond the scope of this. The locus standi was enlarged. Why is locus standi enlarged? To give you standing to object. Standing to object, why? The standing to object, because you have to defend freedom. You have the training to do it, you got the means to do it. So we earned the freedom, and we also got with us the method to defend the freedom which is there. Now, beyond this, there are certain aspects. We dealt with the political aspect of it. Let's go to the social aspect of it. Now, when we talk about the social aspect of it, we are concerned with rights. Up till now, we are concerned with rights. But as the rights is concerned, right to equality is also right, which is an individual right. Yes, but there has to be a balance. What has it to be balanced with? The balance has to be with group disadvantage, with historical exclusion, which may be there, with underrepresentation. Therefore, this has to be balanced. Now, because this has to be balanced, there has to be some method which has to be devised to give voice. Now, the method which was devised to give voice was affirmative action. The affirmative action came in through Indira Sani. Now, when it came into Indira Sani, what was it doing? Indira Sani was speaking for a section which may not have had a voice of its own, and empowering a section to be a participant in the democratic and legal history of the country. Now, this is what happened. As far as this is concerned, it is a very significant moment in our constitutional history. It is a significant moment, but just keep in mind, what Indira Sani talked about was the normative value of balance. This is very important. The normative value of balance is talked about. It didn't deal with reservation only as a matter of arithmetic. And it provided an extremely narrow opening for its breach. But it provided an opening. So what did it do? It fixed a rule, talked of an exception, but did not allow that exception to be enlarged. Control. What is it a control on? Control is on power. Why is there a control on power? Because you cannot politically expand a constitutional discipline. That is the worth of Indira Sani. And the problem today is because the very generous speaker who was more than justified in complimenting me, I don't deserve half the compliments, talked about the reservation dispute. See what the reservation means. As a matter of electoral or welfare gerrymandering, I would call that, and I described it as that. Notwithstanding the constitutional discipline, purely for electoral reasons, and as a populist measure, you breach it. So when you breach it, there's a contest again. Of course, there are different values. This is my view. My view is not the final view. That's the reason why we have an adversarial process. And the adversarial process brings out this particular contest, but that particular process is on. So what is it? Defense of a principle with both sides having a voice and finding a contested meaning of a very significant constitutional value, that of equality. All done within the framework of our constitution. What is the process doing? Forget the outcome, whatever the outcome. Defense of freedom. That is, each side is entitled to express itself. Each side is entitled to say what it believes is actually should be the law. But each side does not have the monopoly to impose. There's a method in which it has to be dealt, and the constitution will prevail as read by the court. So this is where, again, in a very complicated or complex manner, defense works. But as far as this particular group disadvantage is not the only way in which we have dealt with the issue of dignity. Now, we have brought in personhood to a series of judgments, as all of us know personhood, series of judgment in different dimensions. So we have, in Vishaka, we brought in insofar as harassment in the workplace is concerned. That is protection, again, liberty, dignity. Where? In the workplace. No harassment in the workplace, where this is concerned. In Nalsa's judgment, we brought in gender identity. In Joseph Shine, we discarded the concepts of proprietary and paternalistic notions, insofar as Joseph Shine is concerned, and in Johar, we decriminalize a certain kind of same-sex intimacy. This is what we did. But what is the worth? What is the worth of all these judgments? Worth of all these judgments is not in the individual verdicts. The worth of these judgments is protecting an individual as an autonomous person, not as an individual having a state-sponsored role. That is the worth, that is the meaning of these particular judgments. Again, what is it? Defense of freedom. This is evolution of the law. This is not something which is given to us. This is not something which is formally incorporated. This is not anything which is discussed in the Constituent Assembly. This is something which evolved. It evolved with effort. It evolved with habits. It evolved with that genius. It evolved with that effort. And it had an outcome. The outcome was defense. And most importantly, the latest, I just accidentally got to know, read it. It's a very significant judgment of the Sukanya. I think it is Sukanya Shanta's judgment. It's a very, very important judgment where the court examined caste-based classifications. And why am I referring to this caste-based classification is because notwithstanding the recognition in the Constitution and declaration by the court of the worth and value of equality, inequality yet survives. Where does inequality survive? In ordinary manuals, in inherited classifications, and in unexamined bureaucratic practice. We have in one says the declarations of law. We have on the other side the lived reality of life. The lived reality of life has got these problems to it. So freedom, therefore, will have to be defended not only when the government is prevented from acting. Freedom will be defended when structures of humiliation are discarded. That is where our responsibility to defend freedom comes. That is what led to judgments like Sukanya Shanta 2, and that is the awareness which we must carry. Now, from the political rights or social rights, let's come to something bigger. What we come to something bigger is democracy, of federalism, and public accountability. Now, these are things. Now, it's a very vast topic, and we don't have that kind of time. But I will deal with basically three aspects of this, which I personally feel are very important. One, the electoral bonds. Now, electoral bonds, I would say, is a very important judgment, very significant. But the question here is the timing. I'll talk to the timing of the electoral bonds. The electoral bond judgment came after 3 cycles of this duration and actually done. So by the time the electoral bonds judgment is delivered, the job of the bonds has been done. What is the problem over here? And this is something we have to highlight. Delay as a constitutional strategy. And as far as delay is concerned, delay is used in many different ways. Delay is used in the delayed decision making, delays used in even where the speakers are concerned, where disqualification is concerned, delays there. In so far as dealing with the aspect is concerned, delays there with various administrative practices to, in some way, through attrition, through exhaustion, to the sheer fatigue of continuing, make the pursuit futile. But anyway, this is, as far as this is concerned, we have to mark it in our minds. Delay. It's not delay, is not something which you have to condone. The delay is something which is, again, something which has got a constitutional aspect to it. So I will fault the electoral bonds for this. And of the 2 judgments, because it's our colleagues who are hearing it, I personally feel, as far as proportionality is concerned, Justice Khanna's judgment is far sounder on the law of proportionality and the principles than Justice Chandrachud, but that is my personal opinion. That is a different matter. The second judgment I'll talk about is the SIR judgment. Now, as far as the SIR judgment is concerned, SIR judgment, I have a problem with the SIR judgment because of its way in which it handled the principle of proportionality. Now, it relied upon modern dental and Anuradha Bhasin, but it adopted a principle which is not strictly speaking within the 4 corners of that particular principle because it more or less substituted reasonableness for proportionality. And when you substitute reasonableness for proportionality, you in some way rob it of an empirical basis to that particular exercise and leave it more to the intuition. And not only do you leave it more to the intuition, there is also in the process a reversal of onus as to who will actually show that there is in fact a breach which is over there. One explanation for this may be, but that is just an explanation, that whereas the other judgments dealt with fundamental rights, this dealt with a statutory right, because as far as elections are concerned, statutory, not fundamental, and therefore the principle may be in some way defended. However, what is important is, again, there are 2 values at play. One is the accuracy of a role, the other is entitlement to participate. Both values are equally important, and you cannot in any manner subordinate one to the other. And when the law talks about an ex ante justification, you can't make it ex post facto because certain directions are issued and that direction has necessarily to be followed. So this is a personal opinion, but nevertheless, the point is contest of values. There's a clash of views, there's a resolution, and there's a discussion. The discussion is a continuing responsibility, which you, as Adhivakta Parishad, is very correctly doing, bringing into focus to keep our thinking alive, to keep the way in which we approach current, and to make the responsibility to actually proceed with it remain present in this particular process. And finally, after the scene, as far as the governor's guidelines are concerned, a very strange order, which, because first the use of 143, which is more or less an appellate exercise to do indirectly what could not be done directly, is something I have reservations about. But most significantly, there has an internal contradiction in the judgment, because you can't simultaneously say that there cannot be any timelines and yet say it has to be done in a reasonable time, and then give a right of mandamus to deal with it. So there's an inherent contradiction in it. But when there's an inherent contradiction in it, question is, there's a method in which we deal with it. This is subject to scrutiny and examination later, and we are discussing it. And while we are discussing it and examining it, as Adhivakta Parishad is doing, that is the worth of it. We are in the process of dealing with this for the purposes of examining this particular process and defending it. Which brings me to a very current topic over here. Current topic, that is, we talk about judicial independence. How much time do I have so that I can...
So you can conclude.
Right, I can conclude. So we, as far as this is concerned, the various aspects of it. Now let's deal with this one so that I can do it. What it shows is there are 4 or 5 things which these things show. One, our system is resilient. How is it resilient? Because it has learned from conflicts. We had learned from conflict because as a property brought in the limited amending power, emergency brought in a change to 21, 356 brought in Bomai. So we learn. This is the first thing which is there. Second, though the doctrine is strong, its application is uneven. So that's something we have to be watchful of, so that doctrine should match performance. Number 3, there's in some extent over judicialization. Over judicialization can be used by the political executive also to diffuse political responsibility. So we have to deal with that particular aspect also. But nevertheless, it shows courts are active and the executive is concerned. 4, what it shows is the importance of procedure. The importance of procedure, notice, disclosure, hearing, review, repeatedly across. We don't have time to deal with it. The importance of procedure, which is there. And finally, accountability, the worth of accountability, which is actually embedded in this particular system. And to conclude, what I would say is, we as lawyers and the people generally need to get the habit of verification. This is important, because we believe too easily. We have to have a willingness to hear. We should have the necessary flexibility to correct, and we should never let popularity substitute proof. These are the things which we must keep in mind as far as this aspect is concerned, because we must remember that a republic will not remain free merely because power is virtuous, but because power will be required to give reasons, to face opposition, and to submit to correction. And it is in that we will defend freedom.
Thank you. Thank you very much, sir. This was such deeply engaging and thought-provoking address. I think you have given us a lot to reflect upon. I think from the very meaning of word freedom, you beautifully explained how to defend the freedom and judgments that led to defense of freedom and doctrines through which we will defend, and the larger idea of fidelity to constitution. And I think as a lawyer, the line which I will take from this lecture and for life also, that lawyers are constitutional actors. Thank you. Thank you very much, sir. On behalf of everyone gathered here this evening and through all the people who are joined through YouTube, also express our sincere gratitude to you, sir, for sharing your time and your reflections with us. We now come to the concluding reflections or remarks of this evening. It is my absolute privilege to invite Sri Vikramjit Banerjee, Senior Advocate and Additional Solicitor General of India at Supreme Court of India. So I still remember 5 years back, you would not remember, you had given lecture on Constitution on the same day and you enlightened us. I would like you to please give your concluding observations and to place this evening's discussion in perspective. Thank you, sir.
Thank you. I think that the discussion was was a brilliant exposition of law. And I don't think I can add much to what my elder brother and my senior colleague at the bar, Mr. Lekhi, has put forward so brilliantly. So I don't think I have very much to add to what has been stated already about the evolution of the rights of freedom and of the Constitution and our obligation as constitutional actors to be a part of the process. But I will take off from what Mr. Lekhi said about us being constitutional lawyers, and the small sort of note which I have prepared and which I want to speak on, and something which we rarely speak, is what about the future? When I look at our constitution, and this is my very considered view, is that we live in extremely interesting times. We live in times when technology is on the verge of changing everything that we know. And we live in what I like to call the sunset of the industrial age and the dawn of the information age. Information age, this is not the high noon of the information age. That is not what, as in Hindi you would say, that the sun is not in the middle of heavens as well, or madhya gagan mein hai nahi. Magar is just at the dawn of industrial age. And every fundamental thing that we have taken for granted as true, what is your life, what is society, what is state, what is speech, what is their restriction, what is property, what is trade, what is business, everything is up for complete change. I think we do not realize sometimes when we are here, in this wonderful sort of discussion that we are in, and in our courts, because we are so busy in our work, is how fundamentally society is changing around us. And it's changing around us. It's not that we can do anything. It is changing because technology is changing so fast. It is, in many ways, it reminds us almost what happened to India in the 1700s and 1800s, when machines were introduced on a large scale. This is happening globally all over the world. You have seen it in AI, you have seen it in internet, you have seen it in social media and various things of that sort. Now, our laws that we see today, our fundamental rights chapter that we see today, our fundamental duties that we see today, the restrictions that we see today, the entire conception of the world that we see today, our constitution itself is a product of the industrial age. And because it is a product of the industrial age, it takes a lot of things for granted. But the very meaning of what constitutes life are going to change. For example, 5 years back, right to life was right to life. Today, when you have artificial intelligence, and possibly people are talking about intelligent robots, which will be intelligent, which will know, act independently and completely intelligent. That's all part of, you see a video, that's all there. How would you then classify the right to life? When you talk about your right to association, how does social media associations, which are intense associations, which are associations which can completely bring down governments, which can create governments, which can change issues, which can completely direct issues in a certain way. How do they, what is the position of a WhatsApp group? Where would your restrictions come into that? Your freedom of speech. We were used to a certain kind of freedom of speech. And this debate, we've had it for some period of time, longer than the others. What is the extent of our freedom of speech on the internet? On the internet, when a lot of the communication is anonymous. So people behind a pseudonym are saying a lot of things. Sometimes people, and I always say this, that people who are very normal, well-spoken people, and when you meet them one-to-one, then they go on the net and they say very, very extreme things. So, where do you draw the line of freedom to conduct business? What is the nature of business today? What is the nature of business when 10 people across the world are commonly pooling in money to conduct a business? What is the sort of business model which governs something like Airbnb? What is where literally the ownership? What is ownership? What is property? When your ownership is shared across the globe by multiple different people, where these are conceptions, these are things which are happening right in front of us, and this is something which we have to take into account. Now, there are 2 or 3 things which I just want to bring to your notice, that it is important for us that our institutions and our laws, which have been where it is, whether it be our intellectual property laws, whether it be our criminal laws, whether it be our contractual laws, they are changed to suit the times that we live in. They are completely outdated. The legal structure that we see today will be a completely different thing than what we are going to see even 20 years from now, because the things are so fundamentally changing so fast. And this is something which we have to realize. Those who are going to be at the head of the change will come out as winners. Those who will be able to adapt will survive. And those who will not be able to adopt or adapt to these changes, will not survive. And we have seen this in world history happening again and again. When the industrial age came to the world, those who were at the head of the industrial age, they won the industrial world. They came to dominate the world. Those who, like us, came later, but we managed to adapt to it. We managed to survive and to live for another day. Those, like people in Africa who could not adapt, or people in South America who did not adopt, they were destroyed. Now the question is, are we ready? Now, especially us, we as members of a group of people in this country, we are people who are actually people of the Parishad, people like us. We are people who are fond of our traditions, our spirituality, the lessons of our past. And it will be difficult for us, those who have already taken that bus and they can only look forward and they have no time to look at people of their past. For them, they don't care about the consequences. But for people like us who care about the consequences, it will be difficult. It will be difficult for us to navigate the future. But, but as it is extremely important, how do we deal with these questions? When I was thinking about this thing, I sort of came across that speech of Swami Vivekananda, which I think still sort of inspires me, when he said 125 years back, more than 125 years back, at the dawn when India was slowly getting industrialized, he said that we have to embrace change, but yet we have to retain the essence of ourselves and our spirituality and our traditions. And as he always used to say, on one side is boundless freedom, complete freedom to do everything that you want. And on the other side is the deep spirituality of being an Indian. And the path which he advocated, and which I think should inspire us, is to adopt the new while retaining our inherent selves and not giving up the old. That is the challenge, and that is where we today stand. 80 years has passed since we have, 79 years have passed since we framed our constitution, and we are where we are today. It is the next 80 years which will decide for us, as well as the world, where we stand. If we want our Bharat to be Vishwaguru, to be the place where people take inspiration from, and it is important for that because we will be the source. We are the only alternative source to the commercialized, consumerized societies which we see today in the West, which were at the forefront of the industrial age. So the question is whether we will be able to inspire others to take a step back, to think of an alternate future where everything can be shared. The information age, as we all know, a lot of it is shared, and it gives us that opportunity to make that change. But whatever it is, I am sure, especially the younger people of the younger generation, they will be even more confronted by these issues as they come upon us. And I can only wish them, as that famous Chinese proverb goes, may you live in interesting times. Thank you very much. Vande Mataram, Bharat Mata Ki Jai.
Thank you. Thank you very much, sir, for your concluding remarks. And I think what we take from your remarks is that change is the only constant, and what responsibilities we must follow as a youth and as lawyers, as young members of the bar. Also, I would like to quote my ideal. Of course, I should not say my ideal, the youth's ideal. He gives us, Swami Vivekananda, he gives us important way of thinking about responsibility and for this nation as a whole. And he says that this is the great ideal before us, and everyone must be ready for it. The conquest of the whole world by Indian, nothing less than that, and we must all get ready for it. Strain every nerve for it. Up India and conquer the world with your spirituality. So now we move to the vote of thanks. I invite Vidya Pawar ji to propose the vote of thanks. Vidya ji, please.
Thank you, Janvi. It is my privilege to propose vote of thanks on behalf of Adhivakta Parishad Supreme Court Unit for enriching fifth session of Parvatha Rao lecture series. At the outset, we Adhivakta Parishad Supreme Court Unit extend our deepest gratitude to our esteemed speaker, respected Aman Lekhi sir, senior advocate from Supreme Court, for delivering such a thoughtful, provoking lecture on the today's topic, Freedom on Freedom, defended 80 years of independence. Sir, you reminded us to keep our thinking alive and to know our responsibility. Further, respected sir, your insight on today's topic is really illuminating and inspiring to us. Now, we are also thankful to our learned ASG Sir Vikramjit Banerjee for his valuable concluding remark on today's topic. Also, our heartfelt appreciation goes to our organization and members of Adhivakta Parishad Supreme Court for conceptualizing and hosting this important lecture series. I also like to thank you to all participants who have joined today. Your presence and engagement has made today's lecture worthy and successful. Finally, we are also grateful to everyone who are behind the scene to make sure today's lecture as successful. Once again, I thank you all of you. Jai Hind, Vande Mataram.
Thank you, Vidya ji. On behalf of Adhivakta Parishad Supreme Court Unit, I once again thank our distinguished guest speakers, our colleagues, and everyone who joined us online this evening. Jai Hind. I now invite Ishan Kapoor ji for formal closing with Sarve Bhavantu Sukhi.
सर्वे भवन्तु सुखिनः सर्वे सन्तु निरामय सर्वे भद्राणि पश्यन्तु माँ कशिष्ट दुख भाग्य भवे। इसका अर्थ है सभी सुखी हों, सभी निरोगी हों, सभी का कल्याण हो और किसी को कभी कोई दुख ना देखना पड़े। जय हिंद।
Thank you, sir.